Okay. Okay, well, hi guys. It's Ron and Sherry Palmer here from Fixed Family Courts, and we're bringing you a quick and dirty video on something that we believe that we have discovered. It's really exciting for all of you parents because so often you don't have anything that gives you hope or anything that will pay for your attorney. So that's why this is super exciting. This is about suing a judge in their official capacity. So we want to talk to you real quick about this because it's only for people in Texas, and we want to make sure that everyone gets this information so that they can get involved or get notified when we release the rest of the webinar on this, and make sure that you understand how to use it, because you get one shot at this. That's it, one shot.
Hi, welcome to this special release about a pending offer from Fixed Family Courts that we wanted to bring to you immediately because this is, we believe, really big, and there is a time limit on it. So normally from us, you wouldn't hear about things until we are certain that they work and that we've worked out the kinks, but this one is a little bit different because of the time limit. The time limit is 1 year, and after that year it becomes much more difficult, much more expensive to get this relief we're going to tell you about. And so we wanted to make sure that those of you who are running up close to that statutory period can get in and get your rights protected. So what that means basically is that you can get in and file on this issue in a way that protects your right to receive the relief that the state of Texas has said we can get, and it allows you to get that locked in so that you have that right to it, even if we go past the statute before you get things done. So you get to sue your judge and have the state of Texas tell your judge that they need to start behaving themselves and apply the proper protections for your rights. This is very potentially powerful and game-changing, at least in Texas. So
we're telling you about this now because if the courts, the family courts, have infringed or interfered with your certain rights, you need to register for this to get in, because there is going to be limited space on it. And if you want to hear about it on time, for you to have time to file, you need to put this down on your calendar.
And to start off with, just to let you know whether or not you qualify, if within the last year the state of Texas, now this has to be Texas, this applies only in Texas because it has to do with the Texas statute that nobody else seems to have. They have different versions of it that aren't nearly as comprehensive. So if you live in Texas, if your rights have been significantly violated by a state court within the last 12 months, then you are most likely eligible for this relief. What this relief is, it is up to $10,000 in compensatory damages paid by the state. And most of you have heard me say that the state is immune from damages, they can't be sued for damages. Well, I've also said there's an exception to that. That exception is when the state waives its immunity. And in this case, the state has waived its immunity for compensatory damages up to $10,000. That means if you show that your rights were violated under this statute and that your damages were at least $10,000, then you can get that money back. Not only can you get those damages, you can get your attorney's fees paid, your court cost fees paid, and your other related expenses paid. Right? And what that means is you can hire an attorney to do this for you. Right? And they will have a reasonable expectation of getting paid based on being able to review your case and saying whether or not you have a strong case under this statute. And that also means that the state pays all of those fees. So this is potentially a huge impact to the state's budget. If lots and lots of us parents, we're obviously out, our children aged out a few months back, so this doesn't apply to us, and since our children are aged out, we're here helping you guys. We get no more direct benefit from any of this. Just so you know that, and why we're doing it is because we're on a mission now to stop all of these states from doing this. But this is a good way for us to stop Texas from doing this, cost them a lot of money for doing this, and have them rein in these judges and tell these judges that they have to start following the law. This statute applies strict scrutiny to your rights as a parent. And as you've heard us say before, strict scrutiny is the highest degree of protection any right can receive, right? And it is very, very hard for the state to prove. And they have to prove it in advance before they infringe your rights, which, as all of you know, they don't do. Right? So if your rights have been infringed within the last 12 months, there's a good chance that you are eligible for some or all of this relief. There's also declaratory and injunctive relief available that can get your order declared in violation of this statute and can potentially get an order that says they have to undo it. Now, that portion, undoing it, will probably require an appellate step, but it is available.
Right, and so we're going to screen everyone who registers for the webinar because, like I said, there is limited space. We also have limited time to do this. So we're going to screen everyone that would like to register. So you need to start notifying us now if you're in Texas and you're interested so that we can make sure that you're asked the right questions and that you at least appear to qualify.
Right, and so we'll have a more in-depth webinar upcoming in the very near future. We have several products that we will be releasing in the very near future. Basically 2 levels. The first level is it looks like you qualify, and then at a lower entry rate you can get in, get all the details, see whether you qualify, and decide whether or not you're going to go to an attorney and request this relief. The larger package gives you tremendous amount of help from us, direct, and information for your attorney, and help and aid with your attorney with documents, the first versions of which we have already filed on behalf of an attorney-client through another attorney. They have filed these. Right? We are in appellate review right now because the Attorney General is fighting this tooth and nail because the Attorney General knows just how damaging this will be to the state. But we believe we have an extremely good chance of winning on appeal. We think this statute is very explicit in what it provides and what it covers, and we believe that the state will lose on this. And that's why we're bringing this to you now before waiting for the months and months for this appeal to go through, because if we wait those months, some of you will miss out on this opportunity. And we think this is that good that we are willing to put some of our credibility on the line and say, if you qualify, you should not miss out on this. All right, so stay tuned. We're going to post some additional information on this video to show you how to register and how to get this additional information. Remember, it is for Texans only. It is immediately if you have been affected within the last 12 months. Now, if you've gone more than 12 months since your last order that affected you, don't lose hope. There is a way, a longer, a little bit more expensive way that you won't get completely compensated for, but that can bring you back under the scope of this statute and to get this protection. All right, so we will be bringing that out a little bit later because you have plenty of time to do that. Most of you do, and we want to make sure we get this out immediately. And we are as quickly as we can completing these documents. We have a process flow that walks you through exactly how this works, steps you right through the statute and where everything applies. We're attaching all of the case law to it at the moment. There's some very strong case law in Texas. Not against it. Has never been used in family law yet. Right? It's been used in other areas, and there's very, very strong case law. Very, very good opinions from the Texas Supreme Court. And there is a complementary federal law that has a lot of case history from prisoners, and this affects prisoners as well. So it's not just a family rights issue. And so we have, for that reason, we have very good case law on it because their opinions aren't twisted and distorted by the family law presumptions. But we want you to hang tight. We want you to start looking at fixed family courts for our announcements for this. We will put some information here so that you can contact us. If that's not up on this video yet, because we are rushing through getting this out as quickly as we can, if you don't see it on this video yet, just go to Fixed Family Courts, to our contact page, and fill out a contact request and say you're interested in the Texas suit against judges. Oh, I don't think we mentioned that. You will be suing your judge directly in their official capacity. So your judge will have to defend their actions in another state court.
And if you're not subscribed with us, go ahead and subscribe. We will be sending out an email on it as well. So you can, if you are subscribed and you just want to send a contact because you want to make sure that you get on the list, that's fine. If you're subscribed and you just want to wait for that announcement, that's fine as well.
Yeah, though our email list is quite large, so don't presume that we'll know who you are and that you're in Texas. So if you want to be on the short list and the first people to get this information and be able to get the detailed material that goes along with this that will help you and your attorney get you this compensation, then please let us know. I've covered everything, right? We're suing judges. The Attorney General is most likely the person who will be defending, right? So this is directly to the state. The state has waived its immunity. If you're in front of a magistrate or an associate judge or a county judge, you might have a county defender defending the judge. But for any district judge, it'll be the Attorney General. They are tough. We've battled them on multiple. We have multiple battles ongoing with them right now, and yes, they are tough and brutal.
So you're going to want this information because we share that with you. The ones that qualify, that get in on this, we share those details with you so that you know exactly what to expect, so that you can be prepared.
And your attorneys could do this all on their own, but they don't have the parental rights arguments and angles that tie these statutes together, right? You're going to want an attorney to do this because this is pretty much a straight-up tort statute that allows them to sue for damages. But they have to be able to make the parental rights connections that allow this to apply in family law. And as you know, they get very twisted and distorted in denying us our rights. I don't think they're going to be able to deny this one. I think it's too big of a political deal for them to do it blatantly, and I think the statute is too clearly written to allow them to twist and turn this statute.
So the other reason that you didn't cover that there's such a rush to do this is because if the legislators, or let's say the Attorney General, starts contacting the legislators telling them, hey, we need special session, you need to put an exception to family law in there so that it doesn't apply, they could very well convene before their next regular session and put a restriction in there for people in family law.
All right, so they are very aware of this. We are currently battling the Attorney General on appeal on this, as with an attorney-client, and an attorney filed it. So they are fully aware of it, and you can guarantee that those legislators on the Parental Rights Committee, I forget the name of it, but those legislators are fully aware of it, and they're looking at it, and there's a good chance they could call a special session and put an end to this. They're not going to call a special session if one parent does it or if 10 parents do it, but when 100, 200, 300 parents do it, they're going to have to do something.
And if someone succeeds, they may very well likely do it as well. So you want to get in, all of you want to be doing it so that if that does happen, usually, we're not lawyers, but usually when a statute changes, the statute you filed under is still the controlling statute for your suit.
Right, so there's some good, strong case history in Texas on this very issue, and it's about retroactive laws. Our Constitution in Texas has a specific prohibition against retroactive laws, and what that basically means is, and the way it's generally interpreted by the courts, is if a law or statute gives you a right to relief and you have filed suit for that relief, you have vested that right to relief. You have locked that relief in. If you win, right, you still have to win your case, but they can't just dismiss it because the law changes. So if you file suit under a law and the next day the legislature changes that law so that you no longer qualify to sue, you are vested in that previous statute, and your suit will go forward under that previous statute. So that's part of the urgency here, is we want parents to get vested before the legislature comes back potentially in special session and does something to end this. I don't think they can end it directly by saying parents don't get these protections, but they're going to find some sneaky, twisted way to do it.
They can make an exception to where it doesn't apply to the family code. If any of you have been acting pro se, I'm sure you've noticed that there are statutes you'll come across and you'll think you have something great that you can use, and then you'll see that it says that it does not apply to the family code. So that's what they can do quickly and easily.
Right. So at the moment, it absolutely applies to the family code without question. Right. They have to take specific steps to exempt it. But we believe, or at least I believe, that if they took that direct step, it would be too politically sensitive for them to get away with. And it would give us a huge political bat to beat them up with. And so I don't think they'll do it directly, but they are sneaky. They're likely to try some other way. So again, stay tuned to this. Get on their short list for this effort. Sue your judge to potentially get $10,000, get all your attorney's fees paid, and to potentially get your orders overturned and your rights restored to you.